Let's continue on this then. Legal analyst Mpumelelo Zikalala will help us unpack developments at the parliamentary inquiry into the fitness for advocate Busisiwe Mkhwebane to hold office, but also what is currently happening in terms of the bid to challenge the decision of Section 195 Committee Chairperson Qubudile, Dyantyi, DAMP Kevin Mileham not to recuse themselves. A very good afternoon to Mr. Zikalala. Always a pleasure to see you, sir.
Good afternoon to you, and also good afternoon to your viewers.
All right, let's talk about your thoughts then on how the issue of alleged bias was addressed by counsel for advocate Mkhwebane now and before the initial dismissal of the application that she had made, as in what is currently happening at this time.
I think they're well aware of the test of the element of biasness, that the court will look mostly at the applicant and say, we want to view from the applicant's view. Is there any reasonable grounds that would perceive that the person who's going to take the decision is not going to take a decision sober? And I say that in inverted commas, so that they won't be affected by any other elements outside of these particular proceedings. Now, those small subtle comments that will be made during the proceedings are going to be telltale signs of whether you're assessing this element on a non-partiality basis, or have you already taken a side, which is very important as to what you say on both parties, the amount of time that you've given to both parties to argue, and the manner in which you've conducted those particular proceedings. Now, in this case, it's quite a unique matter because it is not only the element of biasness on the chairperson, but there are other committee members that are there. So it's almost as if you have attracted or used the jury style of adjudicating something which you are not really used to when it comes to South African jurisprudence or the manner in which we do things here. So those are the type of issues that you are going to find. And then lastly, if you take a quasi-judicial process and you want to turn it into like a semi-inquiry or an element in which a commission will be used, for example, you are going to find this type of issues because you have many minds who are taking particular decisions, and that can lead to a difference of opinion, that can lead to many applications being made, especially when the ones in which one of the committee members is related or is a spouse of one of the complainants. Clearly, that's a clear telltale sign of saying, remove this particular individual because the element of biasness is going to be raised and is reasonable in the mind of the applicant. And the chances of advocate Mkhwebane winning on this one, I would say they're quite high.
All right. We're essentially dealing with two separate processes here because we have the inquiry on one hand, but we also have this application that we're currently dealing with at the moment. And I heard advocate Busisiwe Mkhwebane saying that, she doesn't want to be accused of, delay tactics, which, sometimes does indeed happen when we're dealing with a number of processes that are happening at the same time. Let's talk about how the one process would ultimately affect the other. You're talking about the fact that it is likely that advocate Mkhwebane could win on this particular case, which is the application. How would that then affect the main, I'm going to call it the main issue, which is the inquiry?
Then it basically means that you have to start from scratch because all the evidence that has been heard now was heard under the provision or the authority of the person who was alleged to have been biased. So the most important question would be, are any questions of clarity that ought to have been sought from a reasonable, unbiased chairperson have been sought? Is the manner of allowing questions to be raised, was it observed? And if the answer to that is no, or there's an allegation that there might have been an overstepping of the mark or maybe suppressing of certain questions being asked, then you've got to come back and say things did not go in the correct manner. Then the whole inquiry has got to start from scratch. So from a time basis, the amount of witnesses that have been presented, the amount of time and money that has been spent, you need to start from scratch with the process.
And that's very interesting given the fact that the Office of the Public Protector is saying, they're already battling financially. I don't want to deal with that issue. It's not my business. But let's talk about the provisions, that are in place when it comes to dealing with perceived or alleged bias by, a chair of a Section 194 inquiry such as this or any other inquiry of this nature. I want to also talk about Kevin Mileham, but I think that, it's a similar situation, when it comes to both parties. But what are those provisions in dealing with those particular issues?
Let's look at them from this perspective. Who's going to take the final decision when it comes to this matter? So who's going to say, Advocate Mkhwebane, you are indeed a person who can be deemed to be incompetent, allegations of misconduct has been proved against you, or you can't really take the competency of the public protector, or you are not really supposed to be in that particular position. So if a person is going to take that particular decision, then we look at them and say, are you going to take this decision without being affected or being influenced by any other factor other than the information or evidence which is going to be provided? What are those factors? One, general dislike of that particular individual, a perceived allegation or a perceived intuition of saying that you may talk and say whatever that you want to talk as Advocate Mkhwebane and your rep. However, I still think that you are guilty. And the utterances of saying that we're not going to subscribe to certain stolen grant activities, we're not going to subscribe to any incompetence, proves that a person, or creates a reasonable suspicion that a person is already alleged or decided on the matter. They're just waiting for the final day so that they can confirm their order. And the most common one is to say, if there's a certain spouse or a friend or a person who is close to the person who's going to take the decision, who is able to whisper in their ear, not officially, either officially or off record, then the perception would be maybe you do talk about this matter in your spare time, and they're able to influence your decision-making process. If that's the case, then how can I trust that whatever decision that you are going to take won't be affected by anything else? Other ones which are mostly used, which may not apply in this particular matter, would be any financial interest that is there, any non-financial interest that may be there in the outcome of this particular matter. So it's everything in which the court is going to look at, but the court is simply looking for one thing. Are there any reasonable factors in which a person who is a third bystander making this application would think that a reasonable decision, or a decision which is unaffected by outside elements, is going to be reached? Are the people who are charged with making the decision only going to look at the evidence which has been provided to them? Now, ordinarily, you'd have 1 or 2 or 3 judges which that application would be made against them. In this particular case, is the whole committee, hence which is why the net has been cast quite wide, so that you're able to capture each and every single one of them and be able to distinguish whether this person is going to make a valid decision-making process, or is it either affected by anything else other than the evidence that has been provided.
All right. Thank you very much. And Mpumelelo Zikalala, it's always a pleasure having you. We certainly do appreciate your well-thought input. Thank you, sir.
Thank you very much for hosting.